expression ambulance trial?
I will never withdraw that. I believe that as if we are in an ambulance mood to get these people jailed. I will never withdraw. That's my sense of it. So even where we should wait for a motion to be heard, Attorney General is in no mood to even respect the rules. And it's on me also, so the judge will just respect what he's saying and obey it. I've seen several things in the court which is telling me that Attorney General is having his own way in that court. And whatever he says, then the judge wants to do it for him. Since we started these matters, that's my strong view of the matter. And I'm afraid justice, whatever you want to call it, should never be at the expense of my clients. You see, if you want a expeditious trial, fine. It should never be at the expense of my client. My client should be given the facilities to contest the case fairly.
But is it fair to the judge to say that it appears whatever the Attorney General wants, he gets in court? 2 objections were held in your name. You requested an adjournment. It was granted. And on all 3 occasions, these were against the strong protest of the Deputy Attorney General. So is that assessment fair to the judge?
It's inconsequential at all, because the Attorney General orally will abrogate time. If you saw what happened, there were motions that were intended for the 29th and the 30th. The Attorney General believes that those motions should not be taken and that the case should be heard, next week. He was obliged. You should open your eyes to see what is going on there. You don't need too much intelligence that, it seems to me that this is the Attorney General's, pleasure, which is being carried out, even if it will cost us injustice.
In terms of the exculpatory document that you wanted, the court is saying that you can't show anything by the fact that AG has them to be able to provide them for you.
The same AG was able to bring the National Security Coordinator's account. Where did he get it from? Where did he get it from? So we shouldn't confuse that if it's in your possession, it means it's in your armpit. But you can commandeer it. That's what the law says. You can place a demand on other law enforcement agencies to bring the documents that will aid the case of the accused persons. And these are constitutional provisions. These are not matters of anybody's invention. Why are we subverting the Constitution with such impunity? As if we are in indecent haste to get somebody in prison. That's my sense of what is going on.
Okay, you have 2 applications pending. What are these applications?
The first one is disclosures. And then I want them to see the necessity to look at whether or not somebody acquired a property in London, at what time, with what money. So if you can't show the nexus between the property acquisition and the so-called account from which these monies were fretted out, then you have a very poor case. So my sense of this case is that what they need, the accused persons need, to destroy the case of the Attorney General, they don't have it. And somebody believes that, with impunity, let's go on because I'm running very fast to get somebody incarcerated. How can you deny somebody his weapons of warfare and hurry him so that somebody will come and say that, this case was not properly conducted? Meanwhile, everything that will expose this case as dangerously anemic and aberration of justice is with them, and they don't want to bring it. How do you process a situation in which, before a judge, are missing pages of documents brought by the Attorney General, and the judge says, all right, we don't have to see the other missing pages? Is that justice? That's why we appealed the case.
And the other application, we talk about the disclosure.
Yes. And stay of proceedings, that we lodge an appeal against the refusal of the disclosures with the Court of Appeal. And we've come to the judge that, look, in view of these matters we've raised in the appeal, you should stay proceedings. Because at the end of the day, if you hurry this trial, and what the accused persons need for cross-examination and defense is not available, you've shortchanged them in an irreparable way, that somebody is going to go to jail because concealing evidence is comfortable with the Attorney General. That is unfair.